Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Hello. Welcome to The Community and the Law, brought to you by BWF TV, BWF Solicitors. Today we are looking at a very interesting topic, something that borders on children's applications, family, partners, spouses, and it's crucial because most of the time we may not have the money to pay for specific applications. How many times can I try to seek support from the government to make this payment? That will be the conversation for today, and therefore call a friend to call a friend, stay glued, and this Community and the Law show tonight, you will take something home that will benefit you greatly. We want to say thank you to BWF Solicitors for continuously championing the best interest for the community and also bringing you this show every Saturday. We are going to go for a quick commercial break, and when we return, we will be looking at celebrating specific events and also taking you into what we have for the day. Remember, the topic for this afternoon is, why has my fee waiver request been rejected? Point 1. And can I make another fee waiver request? That is what we'll be looking at this afternoon. Stay glued, don't go away. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to the show brought to you by BWTV, your best media broadcast platform in the UK. So we have taken you through the necessary things. We've told you what the topic is. Today we are going to have some celebrations. So we go through the celebrations. The first celebration is to do with the birthday celebration of lawyer Annie Akofio-Sowa. Annie is one of the lawyers at BWF Solicitors. It is Annie's birthday. And on this day, we celebrate Annie and we say that may your God continue to order your steps and make you an outstanding lawyer for your community. All the best, enjoy, and we celebrate with you, Annie. So the next is also what our clients are saying. At BWF Solicitors, one of our hallmark is to make sure that every day our clients have something to celebrate about. It's all about client satisfaction, client satisfaction, client satisfaction. So this is a client who is satisfied and came back to say thank you. I'm so grateful to BWF Solicitors for helping me win my spouse visa case. From the very beginning, they were professional, knowledgeable, and genuinely cared about my situation. The team guided me through every step of the process, from gathering documents, the attention to detail, and clear communication made a stressful situation so much easier to manage. Thanks to their hard work and expertise, my spouse visa was approved. I can finally be with my partner. I highly recommend BWF Solicitors to anyone looking for reliable, compassionate immigration support. Thank you again for making this possible. Thank you to Matilda for coming back to share your experience. BWF Solicitors, our aim is to make you happy, achieving what you think cannot be achieved, and making you enjoy success. Thank you, Matilda, for your feedback. So that goes to everybody that at BWF Solicitors, we don't just give you what you need, we give you a testimony. And this is one testimony from Matilda. Okay, yeah. So after the celebrations, we're going to take the commercial break. After commercial break, we'll go through the nugget. But we'll just share the nugget briefly so that after commercial break, we'll discuss the nugget. So producer, the nugget for this afternoon, it says under a short hold tenancy agreement, landlord has a duty to protect a tenant's rent deposit through a deposit protection scheme. This duty must be carried out within 30 days of receiving the deposit amount from the tenant. Failure of the landlord to do so may lead to the landlord paying back 3 times the deposit amount to the tenant within 14 days of a court order. And this is taken from sections 213 and 214 of Housing Act 2004. Housing Act 2004. So we now go for a quick commercial break. When we return, we'll dissect the nugget and also look at the question that goes with the nugget so that you can have your opportunity to discuss among yourselves, friends, and family and be able to get an answer when we get to the quiz stage.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for staying glued and welcome back to the show. The Community and the Law program brought to you by BWTV, BW Media, and proudly sponsored by BWF Solicitors. So we are going to dissect the nugget and we will look at the question that goes with the nugget and that gives you opportunity to also have a go at that. At the tail end of the program, we'll revisit that question, take your answers, and wrap it up. It's a collaborative approach to discussing and learning, and it's all about legal empowerment. So the nugget here is actually about right of tenant in the UK. Every tenant takes occupancy of somebody's property and pays rent. Before that, the person will have to pay a deposit. The deposit is paid to the landlord or the landlord agent. The question is, what do they do with the money? And do they give it back to me after the period? So under the law, that's the Housing Act 2004, sections 213 and 214, places a duty on the landlord to ensure that the money is not kept at home or kept in a personal account, but kept with a protected deposit scheme by the government. So that at the end of the day, Once the tenancy is over, the tenant can get the money back. In this case, the landlord will not have opportunity or access to the funds to misuse it. And so the duty must be carried out within 30 days. So if you give the money, which is the deposit, to the landlord today, and today's date is 15th of November, we expect that by 30th of December, 30 days, the landlord or the landlord's agent will confirm whether the money has been deposited into a scheme, which scheme, the contact details of the scheme, so that the tenant can have access to the scheme. At the end of the day, it is not the landlord that will have to make the money available. It is the scheme that will make the money available to the tenant. What if the landlord doesn't? Once the landlord fails to do so within 30 days, the tenant has a right under the law to go to court, county court specifically, to make an application for an order to let the landlord pay back the deposit money to the tenant, and this time 3 times the money. So if you pay £1,000, an order will require the landlord to pay you £3,000, and so on and so forth. And such order, once it is made, the payment to the tenant must be made within 14 days of the order. So these are the specific duties and the rights for the landlord and the tenant under the Housing Act 2004. So if you have made a deposit and the landlord is not able to tell you where the money is, or the landlord's agent is not able to tell you, you have a duty, you have a right under the law to go to court, complain to the court, or make an application to the court. Court will look into it, make an order, and you get your money back plus more, 3 times what you paid. That is the nugget. So we are now going to look at the question that goes with this nugget and give you opportunity to be thinking about it so that we can discuss later and take your answers. So this is Ashraf, who has entered into a tenancy agreement. And here we are looking at short hold tenancy. Usually short hold tenancy is 6 months, 1 year agreement.
Ex-skilled worker dependent switched to 5-year partner route with a new British partner. The skilled worker's ex-partner successfully applied to switch to a new spouse visa as the spouse of a British citizen. Case overview. Our client came to the UK in 2023 with her husband, who was a sponsored skilled worker. Unfortunately, their marriage broke down because she met a new partner. The challenge: divorcing and marrying within a short time. Our client had received a letter from the Home Office stating that her ex-husband had reported that they were separated. She was given 60 days to switch her visa or leave the UK. She was advised that, as they were married in Ghana, she could file for divorce in Ghana. She followed our advice and obtained a court divorce from Ghana. She subsequently entered into a customary marriage in Ghana. Proxies represented her and her new husband. Once the marriage was registered in Ghana, she was ready to make her application without leaving the UK. Our strategy. As a result of the visa cancellation, our client needed to act quickly. We advised her about the lawful way to obtain an overseas divorce under the Family Law Act. Additionally, we ensured that the subsequent marriage complied with the stringent UK laws regarding the validity and genuineness of the relationship. With our vast experience in family and Ghanaian law, we ensured that she had the best chance of success. The outcome: spousal visa, granted within priority processing. The spouse visa was granted within priority processing timeframes, enabling the new couple to move forward with the marriage. This case illustrates how speed and knowledge of family and Ghanaian laws can be effectively leveraged in time-sensitive cases, particularly for dependents facing visa cancellation. Facing complex immigration issues? Contact BWF Solicitors today.
So that was a piece of testimony from BWF solicitors, how to ensure that regardless of 60 days from the home office, you're still able to navigate with expertise, advice from BWF solicitors to ensure that you do not become an overstayer in the UK. If you find yourself in that situation, remember there's still an opportunity for you. Don't say that you've got 60 days and what do you do? Knock on our doors, we'll sit with you, discuss with you, work with you every step of the way, and ensure that one, you are protected under Section 3C of the Immigration Act, and also you go through the next opportunity process to ensure that you retain your leave to remain by switching to the available categories. Now to Ashraf. So Ashraf's tenancy is for 1 year. Ashraf entered into this tenancy on 1st January 2025 with Uma Patel. He paid 1,500 to the landlord's agent. He has been chasing the estate agent to confirm the name of the deposit scheme the money was paid into. Up to date, this information has not been shared with him. Up to date means that we are in November and this was January tenancy. So for the past 11 months, no information. That is more than 30 days. Advise Ashraf about his legal rights. 1. Ashraf can complain to the legal ombudsman to get his money back and he will receive 4,500. 2. Ashraf should apply to the county court for an order to get his money back and he will receive 4,500. 3. Any of the above can be the way for Ashraf. Think about the answers. Think about the question and have your answer ready. At the end of the show, we'll come back to you to ask you what you think. Okay, so before we go into the conversations for today, we're going to go into a quick commercial break. When we return, remember the topic is, why has my fee waiver request been rejected? We'll look at the reasons for rejection and whether I can make another application for a fee waiver or not. And whether I can do so or not depend on my protection under Section 3C as well. So think about the topic, get ready, pen, papers ready. Soon after the commercial break, we'll delve into the topic.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome to the show, and thank you for staying committed. We are going straight into the conversations. You are with Lawyer Charles, one of the lawyers at BWF Solicitors. Lawyer Charles is our resource person for today. So, lawyer is going to take us through the various aspects of fee waiver and whether somebody can apply again once a fee waiver has been rejected. We'll be looking at what fee waiver is by way of refresher. We'll look at aspects of applications that fee waiver covers. We'll look at the requirement for a fee waiver grant or acceptance and look at how a fee waiver or why a fee waiver could be rejected. We'll then look at someone who has been rejected a fee waiver, whether the person can apply again or not, and the consequence thereof. We'll then wrap it up with your questions by dialing into the show and by sending your messages. Now we have the studio numbers. So very soon we share the studio numbers with you. But just so you know, the topic for today is why has my fee waiver request been rejected, and whether I can make another application for a fee waiver. So we are going to ask the producer to share with us the resource for this conversation. But by way of overview, a fee waiver simply means that you cannot afford the application fee, and so you want the government to accept to give you a fee waiver token or a code to be able to pay for the IHS fee and the visa fee. The visa fee is currently £1,321, and the IHS fee is £2,587.50. Altogether is about £3,910. Can I get this for free if I cannot afford? How do I prove that I cannot afford? What if I can afford, but after affordability, I will not be able to meet my living needs, especially where there are children involved? What do I do? So, fee waiver is largely for human rights applications. Producer, if the resource is ready, please let us have it. So, fee waiver, human rights based, and other specified applications. And this is version 7, September 2024. So, it's under 1 year old. And we are looking at what this is about. And we've said that this guidance tells you how to consider requests for a fee waiver. So, this is for a caseworker. This is the document the caseworker will use and follow to be able to decide whether to grant you the fee waiver or not. So the guidance tells how to access the fee waiver request. Now, separate guidance will be available for specific fee waivers. Now, it says that the guidance does not apply in circumstances where no fee is required. So where you don't require a fee, then this will not be applicable. And it says that for individuals applying for permission to remain based on Article 3, whether as part of a claim for protection on the basis of a medical condition or not, or a child in local authority. So there are certain things that fee waiver will not apply. But let's move straight into eligibility. So applicants are eligible to apply for a fee waiver where they wish to make a specified human rights application and to require payment of the fee before considering the application would be incompatible with their rights under European Convention on Human Rights and also the Human Rights Act 1998. And there's case law to that. The case of Umar, the case of Carter, and the case of Gineku all talk about the same principle. The courts have considered fee waivers in an immigration context in this specific circumstances. And so the Home Office workers or case workers are required to ensure that they follow the statutes, they follow the guidance, they follow the case law to ensure that people are not disadvantaged when making immigration applications and they cannot afford. So the guidance applies to the following applications. So if you're applying for a fee waiver, it's not just because you are making an application you need a fee waiver. You have to check whether your application is one of the following. So one, applications for permission under 5-year route partner from applicants who are not required to meet the minimum income threshold because the sponsor is in receipt of specified benefit. So there are some spouses who will be making application to sponsor their partners from abroad or within the UK. And those people are receiving benefits, specified benefit, especially what we call payment, personal independent payment, PIP, and other forms of support from the public purse. So such people who are receiving specific benefit, if they do not meet the 29,000 threshold, they can apply for a fee waiver for that. Or if they cannot afford, they can also apply for such fee waiver. So fee waiver is not only for parent applications or children applications, it's also for partner applications where the partner is disabled and receiving disability support. There's also instances where members of people who are applying for adult dependent relative visas and cannot meet the maintenance can seek help from the fee waiver request process. Applications for permission under the 5-year parent route. So you're applying as a parent to remain in the UK with your child who is a British child or a child who has indefinite leave to remain. That's a qualifying child, so to speak. You can ask for a fee waiver. Applications for permission under 5-year route private life under private life route. Private life is mainly 10-year route. Sometimes there are instances where private life may be granted under 5-year, but that is limited circumstances. Applications for permission under the 10-year partner, parent, or private life is also allowed as far as fee waiver is concerned. Making application for permission on the basis of other human rights. So human rights here, Article 8, Article 3. So Article 3 is where if you are sent away from the UK, your life may be at risk. And so you are seeking some form of support in the UK by way of leave to remain. Or Article 8, where there is family and private life considerations. Applications for further permission from applicants granted discretionary leave. So if you are making an application on discretionary leave basis, following refusal of your asylum claim, you can also ask for a fee waiver if you cannot afford the fee. Applications for permission to stay in the UK as a child under Appendix child staying with a joining non-parent relative. That is Appendix C and P. So if you're applying as a child who is wishing to remain in the UK with a non-parent relative, so an aunt, an uncle, and so on and so forth, depending on the circumstance of the child, you can also apply for a fee waiver. So we have all these categories that fall under Article 8 and Article 3 as far as the human rights considerations are concerned. What does this mean? It simply means that fee waiver is only for applications that are within human rights. Article 8, Article 3, and other aspects of human rights considerations. So let's bear in mind, if you are making an application to extend your visa in the UK as a student, skilled worker, and so on and so forth, you cannot apply for a fee waiver because they are not human rights applications. It says that applicant will only be granted a fee waiver on the basis of human rights in cases where the underlying human rights application on which they rely forms a substantive basis of their application. This will not be the case where, for example, the human rights application is mentioned in passing as part of an application which is primarily made on another basis. What simply means is that what you are applying for will determine whether you can get a fee waiver for the fee or not. And the application should be a substantive human rights application. As a parent, as a partner, or discretionary leave to remain, what we call leave outside the rules, and so on and so forth. If it is not a main human rights application, you will not be granted. And there's case law to that. Now, before we move on, let me also take you to Section 6 of the Human Rights Act 1998. Human Rights Act 1998 says that if somebody is unable to make an application, which is a human rights application, because they cannot afford the fee, then their right under the law within Article 8 is not protected. In this case, such a request for a fee, if the person cannot afford, will be incompatible with the law. And therefore, when making fee waiver application, you have to draw the attention of the caseworker to the fact that if the fee waiver application is rejected and they cannot afford their fee and they are forced to pay, then that will be a breach of Section 6 of the Human Rights Act 1998. And it says that applying for permission based on Article 3, whether as part of a claim for protection or on the basis of medical condition, can also be a basis for the fee waiver to be considered. So we also have children who are in local authority care and so on and so forth. All these are considerations that the caseworker will have to have before deciding to grant or not to grant the fee waiver. So, producer, let's go to assessing the fee waiver request. Assessing the fee waiver request. Before we move on to assessing the fee waiver request, we'll take a quick commercial break. And when we return, we are going to look at what the caseworker should be looking for when making assessment. But before that, let's bear in mind that to be able to make the application for the fee waiver, you have to check that you cannot afford the fee. You have to check that if you are able to afford the fee, members of your family, including your children, will not be able to meet essential living needs. Or if you are able to afford the fee and you pay the fee of £3,910, you'll be left with nothing, and therefore you are likely to face imminent destitution in terms of ability to survive. These are the things the caseworker will have to bear in mind before making a decision to accept or reject. We'll take a quick commercial break. When we return, we'll be looking at how to assess a fee waiver before granting or rejecting. We'll be right back. Stay glued.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, viewers and listeners. Welcome to the show, the Community and the Law program, brought to you by BWTV and proudly sponsored by BWF Solicitors. So we have to just get back to you, but remember, we are going to delve into the discussion. We turn around and come back shortly. Give a minute. Producer. So quick commercial break.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon and I am your host.
Thank you for returning to the show and thank you for your loyalty. We are going to delve into the discussion. We're going to look at how to assess a fee waiver application. And this is what a caseworker will be doing. Before that, let me share with you the studio number and the number to dial once we are ready to take your questions. So the number to dial, the studio number is 073 992 992 8468. 073 992 8468. So that is the studio number.
Case overview: a successful appeal at the upper tribunal. Our client, a national of Ghana, applied for an EEA family visa permit, relying on his marriage to a national of Germany. After a significant delay, the family permit was issued, and he arrived in the UK. A subsequent application under the EU settlement scheme was refused, and the appeal went to the upper tribunal. The challenge: proving that although our client's sponsor held a British passport in addition to her German passport, she was a relevant sponsor under EU settlement laws. The Home Office argued that as the sponsor was a British citizen, and although she was born in Ghana, she was a British citizen at birth. Therefore, her European citizenship did not confer any right on our client. Our strategy: proving that our client's sponsor did not automatically acquire British citizenship at birth, as the parents were not married. We gathered evidence that the sponsor's father was still married to his first wife in the UK before the sponsor was born. We relied on the 1948 British Nationality Act to challenge the Home Office assertion. In addition, we provided evidence going back 30 years to prove that the sponsor could not have been British at birth. A successful outcome. The upper tribunal allowed the appeal. They agreed with us that the sponsor was a relevant sponsor, and that she only acquired her German citizenship before acquiring her British citizenship. After 4 years of fighting the Home Office, our client can now stay with his wife lawfully in the UK. Key takeaways: understanding that the only way to win a complex legal case is to painstakingly collate evidence, apply the evidence to the facts, and make the law relevant to your case. Ensuring that in appeals, the best way to win is to ensure the court bundle has the relevant evidence to support your skeleton argument. Always take legal advice where the facts are complex and require diligence and persistence. Facing complex immigration issues? Contact BWF solicitors today.
Hello, this is a short video for people who are here as skilled workers and skilled workers dependent. We have identified worrying trends in the community over several months. On average, I receive about 100 calls, and about 70% of those calls relates to this problem that I'm going to talk about. The problem that I've identified is that migrant workers' sponsors are reporting them to the Home Office for their visas to be cancelled. And it could be for so many reasons, but what I've identified is that most of the sponsors are reporting you, the migrants, because they haven't done their jobs properly. As you all know, when somebody sponsors you or a migrant to the UK, they have 5 duties. The most significant ones are the reporting duty, the record-keeping duty, making sure they're compliant with the immigration rules and the UK laws, making sure that they have integrity and they are above complaint. Unfortunately, for some of these sponsored workers, the sponsors have had arrangements in place to support you. And of course, they are aware that you are not turning up to work, which clearly is against the immigration rules. So what they're doing now is that because the Home Office is aware of this problem, that some workers are in the UK and they haven't even reported to
Welcome to the show, the Community and the Law program. So we are delving into the discussion, but before that, please be aware that you can phone into the program to ask a question, and the studio number is 07399208468. 073. Okay, yeah, so the studio number is right there, 07399208468. If you are using WhatsApp, the WhatsApp number is 079504227 780 07950422780. That is the WhatsApp number. And if you want to dial directly, is 0208 493 7345. 0208 493 7345. So all these free numbers are accessible. You can phone in once the phone lines are activated. In the meantime, we move straight into the conversation. We are looking at fee waiver. So we now move on to look at how to assess the fee waiver. So the producer, please take us to the rule book. So assessing a fee waiver request, and this is to the caseworker, to the Home Office caseworker. When assessing a fee waiver request, you must grant a fee waiver where the applicant has credibly demonstrated that they cannot afford the fee. So the key word here is affordability. If the person has been able to prove that they cannot afford, you have to give them the fee waiver. What if the person is not able to? That means they cannot grant the fee waiver. This includes where the applicant's income is not sufficient to meet their child's needs, or payment of the fee would leave them unable to meet their child's needs. So the key word there is where there are children involved. It makes the fee waiver application easier. But doesn't mean that where there are no children, you cannot apply. You can still apply for a fee waiver if there's no child, but you can also not afford as an adult who cannot fend for themselves because they do not work, or they work but the income is not enough. We're going to go into a bit of detail in terms of our assessment. Each case must be considered on its own merits. The responsibility or onus is on the applicant to show that they qualify for a fee waiver. So it's not up to the caseworker to come and tell you, bring this, bring that. You have to provide everything to the caseworker. However, the caseworker can come back to ask for clarifications or further information under the evidential flexibility rules. When assessing whether the applicant meets the criteria for a fee waiver, the caseworker must consider the whole of the amount to be paid. And in this case, we are looking at 3,910. That is the application fee and the IHS, where an applicant can pay the whole amount but cannot pay, for example, the IHS fee. The immigration fee will be required and the waiver will be applied to the IHS. If the applicant is unable to pay the fee and the IHS, you must give both. So it's possible for you to be given the fee waiver in part. Sometimes you go for full and you get part. Sometimes you go for everything, you get nothing. At the moment, there's a case I'm working on. The person, we applied for fee waiver. They made the assessment. After challenging, they came back and said that, right, we are happy to give the fee waiver for the IHS, but the person must pay the visa fee of 1,321 because they see money in the account and there's balance, which suggests that the person can pay part. So sometimes he can pay part, but even if you're able to get 50% of it, is better. So this person I'm talking about was able to get a whole IHS fee of £2,585.50 as a waiver. Some other people got everything, the entire 3,910. But it's your responsibility to show that you actually meet the threshold and that you cannot afford. Please scroll down. So it says that where someone has applied for settlement but did not meet the requirement and is being considered for a grant of temporary permission on the basis of family private life instead, you may need to request an IHS top-up. Where an applicant states that they cannot afford the top-up, a waiver for IHS must be considered in accordance with this guidance. For further information, see the settlement. We know that settlement is indefinite leave to remain. Indefinite leave to remain does not attract a fee waiver. You have to pay the fee. But if you don't qualify for indefinite leave to remain, you have to be given 2.5. And in this case, your application will be assessed as if you are applying for a leave to remain. Where application is being assessed under leave to remain, and the IHS was not part of the application fee, Home Office will come to you to ask you to pay the top up for the IHS. In this case, they will give you opportunity if you cannot afford to apply for a fee waiver by extension of time. In this case, you can go through that. That's why it's saying that where the person is applying for indefinite, but because they are not up to 10 years, they cannot be given indefinite leave to remain, but they are going to be given 2.5. You have to ask them to pay the IHS fee or give them opportunity to apply for a fee waiver and wait for them to get a feedback on the IHS, on the fee waiver request before a decision can be made. So all these are available, and therefore you have to make sure that you go through the steps. Now, we are going to go into assessment. After that, we'll come back to granting the fee waiver and refusing the fee waiver and Section 3C leave. So, producer, now we can go back to the full screen. We'll go through some calculations, after which we'll go back to the rules. So, let's take a case where somebody is applying for fee waiver, and obviously the person cannot afford. That's why they are making a request for this waiver. So this individual is applying for extension of their leave. We have taken all their income into account. They are earning £2,000. £2,000. The person has two accounts, one a Monzo bank account and the other one is Halifax bank account. In the Monzo bank account, we have zero balance and the account is inactive because the Halifax account is the account that the person actually uses. The person has no other bank account. So these two accounts must be recorded on the fee waiver application as the account the person holds. Because we know that the Monzo account is inactive, but if it's inactive, dormant, but it's not closed, so we have to get 6 months bank statement. Then the Halifax, we have to get 6 months bank statement. And 6 months is up to the date of the fee waiver application. So the fee waiver application is today, 15th of November. Then we have to calculate this backward for 6 months. 11 minus 6. 11 minus 6 will give you how many you need to check up to. So we know that we have to go down to somewhere May, March, to be able to get what the person needs in terms of the 6 months. So let's calculate. We are in November 15th, so we count back. We go down to October, we go down to September, we go down to August, we go down to July, we go down to June, and we go down to May. So May 15th, 6 months from May 15th to 15th of November. And that is inclusive because the application is today. Then we go through each item line by line. Any amount, £250, whether in or sent out, must be explained. We see that the money was sent to Charles Asma. So we are asking this person, why did you send money to Charles Asma? What for? The money was £1,000. Then Charles Asma must be able to explain in the form of a letter why the money was sent to them. And Charles is explaining that the money I received was for repayment of a loan I gave to John when John needed money for X or that, or to be able to pay for rent deposit or to buy food or for surgery or for whatever it is. You gave a loan to the person. So I will have to write a letter to explain why I gave the money and the fact that the money is being paid installment to me in the form of loan repayment. Then the person will have to explain this on the bank statement. £1,000 received, or £1,000 paid to Charles, a friend who gave me a loan for XXX, and I paid back. I'm paying installments. So you have to explain. That is called annotations. Each item must be annotated on the bank statement. You do it like that, or you have to do it on a word processing or sheet of paper, either handwritten or typed up, saying that date, amount, received or paid out, reason, or purpose so that it's clear to the caseworker. If you don't do that, they will come back for explanation. If you don't give them explanation, fee waiver application or request will be rejected. So we've done the annotations, we've checked everything, and we realized that the person's income is fixed and average of about £2,000 a month. All the other, he's paying loan, the person is paying for this, the person is paying for that. So we are going to include all the payment on another sheet of paper as expenses. So we have income and expenditure. Food is main item. Clothing, important. Then, so food, clothing, shelter. So your rent, your clothing, your food every month. You are alone. Your food, it's up to you. Average of 250, you indicate. 350, you indicate. Some people eat out all the time. So average of, let's say, £40 a day. Then we have to put all together. Some people buy shop every month. So we look at monthly grocery shopping and put all together. If you have the receipt, fantastic. If you don't have the receipt, then we have to use the average amount for spending to gauge as assessment on food, clothing. Clothing, you don't shop every month. Most people will buy clothing every 3 months. So normally when clients come, they say clothing is £500 every month. Then we can divide by 3 to get the monthly level. This is where there are no children involved. Where there are children, we have to do the same for the children. Then we come to your rent. Rent is fixed. If you are not renting and you are with a friend, you may be contributing to bills. We'll add all that. Some people, the rent will show in the bank account, so it's easier. Where the rent is not paid directly from your bank account, we have to show that this is the rent agreement or the tenancy agreement and the rent you are paying. So these are the 3 basic expenditure. And we come to other expenses. Grooming. So you go cinema, no, that's entertainment. But in terms of grooming yourself, so your haircut, your braiding, salon stuff, again, toiletries, creams, all these are important for your grooming. We put all this together. Toiletries, so you're cleaning your soap for bathing, soap for washing, all these things are important. We put all this together. Then you have parents, you send the money, so money to your parents, we'll add it to that. We put all this together and we realize that your outgoing is £1,950. So your income is 2,000, your expenditure is 1,950, and the difference is £50. Question: can you use £50 to pay for the visa fee of 3,910? So what we usually do is to calculate how long it will take you. So if the fee is almost 4,000 and you have £50 left after your expenses, then you have to save £50 for how many months? So 4,000 divided by 50, that's 40 divided by 5 is 8. So for 8, we are looking at having to save for about 80 months. Can you save for 80 months? And then you cannot even put in the application. So the argument will be that our client has surplus after expenditure of £50. That means he has to save for 80 months, which is how many years? And so without a fee waiver, the person cannot apply for human rights application to remain in the UK. And so it is important under Section 6 of the Human Rights Act for our client to be granted a fee waiver so that he can go ahead to make the human rights application. It will be granted. So everything must be specific. The income or the sources of income, the expenditure or expenditures, put them together. Let's look at expenses that can be considered to be out of scope. Out of scope expenditure are the ones that are not relevant to your living needs. For example, you are giving charity support, £100 to cancer research. We're not sure. You've been going on holiday and you are ticket of about £1,000, 1,500, and so on and so forth, that flight, is this relevant? You don't have money. You have to plan for your application. So this can trigger that no, this may, unless of course it was necessary for you to travel for example, attending family funeral or anything like that. It was a one-off. Then we can argue that yes, the travel was necessary, and that is why the person had to spend what they had to be able to travel. And so it is not that they spent frivolously, but that it was necessary expenditure on that occasion. So the expenditure must be necessary. If it is not necessary, it will be counted against you. So let's bear that in mind. If you have children, you do that. Once you put all this together, you'll be able to then explain to the caseworker that in terms of affordability, I cannot afford. Or even if I'm able to afford, I cannot be able to meet my living needs after putting in my application. You check your income if you are working. So your salary is crucial. If you are receiving support from other people because you are not working, those people must be able to give you a letter explaining why they are supporting you. Every amount of money in the bank account must be explained if it is £250 or more. So let's bear that in mind. Now, producer, let's go back to the consideration of whether to grant or not to grant. But before that, let's remind ourselves of the studio lines. Very soon we'll be opening the studio lines for you to dial in. The studio number is 0208 0208 493 7345. 0208 493 7345. And the other number is 073 9920 8468. 073 9920 8468. WhatsApp number is 07950 422-780. 07950-422-780. These are the studio numbers. Very soon the lines will be activated. You can dial in. If you also want to text your question, you can text the question to the line or to the WhatsApp, the Facebook platform, and we'll be able to pick and read to answer them for you. Now let's go to the guidance for assessing this. Let's go to the guidance. So we are looking at somebody who has been granted or refused. Let's go to the granting the fee waiver grant. Scroll down, grant. So granting the fee waiver request. Applicant on the basis of family and private life. So applications for family life. So parent, partner, and private life, 20 years in the UK or less than 20 years with insurmountable obstacle. If an applicant is granted a fee waiver for the application fee, they must be issued with a unique reference number to be used, which is the code. So that is a token. The fee waiver token is a code. This will be used when applying for permission to stay. This application must be submitted within 10 working days. That's why you are given 10 working days of the actual date of the fee waiver. And they must then make the application and so on and so forth. Now, what if the application is not going to be granted? So if the application is not going to be granted, that means it's going to be rejected, fee waiver rejection. So refusing a fee waiver request. Please, producer, refusing a fee waiver request. Refusing a fee waiver request. So if you are not satisfied that applicant qualifies for a fee waiver, you must refuse the request and inform the applicant of the reasons for refusal. And these are the reasons that may be cited. 1, can afford the fee. You tell the applicant that we know you can afford the fee because we know you have bank account balance of this, you have that, and so you'll be able to afford. The one I was working on, as I said, the person was finally granted a part fee waiver of 2,587 because they were able to pick a balance of 2,300 and something pounds. And they wanted to know what this for. So then I had to argue to say that this 2, 3, thereabout, part of it is for rent, part of it, this is for a loan she's paying, and therefore she'll be able to pay 1,000 as part of her contribution. But they accepted the IHS and asked the person to pay for the visa fee itself. So the person is paying 1,321 and saving 2,587. So you have to tell them that they have not provided evidence and information on their financial circumstances, which is not reliable. They have provided information which are not reliable, and so a proper assessment cannot be made. So if you are not able to provide enough information, or you provide information which are not clear, they will tell you that the information you provided cannot be assessed to determine your ability to afford or not. You have to tell the person that the person has not provided sufficient evidence to support the claim. You have to tell the person that the person has intentionally disposed of funds. So here is very important. It is possible that as you spend your money, you also be making the fee waiver request. But they will check to see, you spend this, you spend this, you spend this. It appears that you've deliberately spent all this just so you have nothing and so you can make your application. Why did you have to spend this, knowing that you have a fee to pay of about £4,000? We put together, you spent about £6,000 within 1 month before your fee waiver request. What for? Why didn't you wait to make your application with this money? And that is what we mean by intentionally disposing of funds so that you can meet the fee waiver threshold or assessment test. So your job now will be to show that the disposal was not intentional, but it was necessary spending. The person has been making purchases beyond their essential living needs. We've explained that you are spending is good, but we want to know whether this spending is necessary in terms of your everyday needs, your clothing, your shelter, your food, and other spending. Are all these necessary? You've been doing this, you've been doing that, you've been doing this, you've been doing that. And therefore, we see that you are spending beyond your ability. And so you are reckless with spending, and that is why you cannot afford. They will reject the fee waiver. Has not taken reasonable steps to save for the Right. So these are the things the caseworker will look at to refuse the application for a fee waiver. 1, that you can afford. 2, that the evidence you provided are not enough to assess whether to grant you or not. 3, that the evidence cannot be supported and therefore the claim fails. That you have intentionally spent the money so that you can get around the fee waiver. So they will find out. Or you have been purchasing or spending the money just so you can beat the system, or that you have not been careful and good enough to plan towards the fee. So they have to give you a reason why you have been your fee waiver has been rejected. The list is just a sample. Could be any other reason they can have, and therefore it is not exhaustive list that can be referred to. Question: if my fee waiver is request is rejected, can I apply for another one? So we now know why you have been the fee waiver has been rejected. Can I apply for another one? Now let's look at Section 3C considerations. Under Section 3C of the Immigration Act of 1971, once you put in a fee waiver and your visa has not expired, you are okay. But once the fee waiver is pending, your visa expires, then you are covered by the rules under Section 3C protection that once the person put in the fee waiver before the visa expired, they are covered. And therefore, once the fee waiver is successful or not successful, they have to apply for the main application within 10 working days. So the next timeline will be that fee waiver has been rejected today. Your visa has already expired whilst you are waiting for the fee waiver. So you're only hanging on to the branch of the fee waiver request. Fee waiver has been made and is decided and is being refused today. You have 10 working days to put in the application. Can you put in another fee waiver? You cannot put in another fee waiver because once you put in another fee waiver, the protection will not work again anymore because the fee waiver you have made whilst waiting, your visa has expired. And so technically, you have now been without leave. But you've been without leave simply because you are waiting for the fee waiver. So if you don't use the fee waiver decision time to put in the application so that your leave protection will continue, and you put in another fee waiver simply because you still think you cannot afford, then you become an overstayer the moment the 10 working days is up. So let's bear that in mind. So the question that follows is, can I put in another fee waiver request once this one is rejected? The answer is you can if you have enough time. In other words, if your visa has not expired, you can put in another one. But if your visa has already expired and you are covered because of the fee waiver you were waiting for, then you cannot. Because if you do, you run out of time and you become an overstayer. So that is the technicality we have to bear in mind. Example, somebody has made a fee waiver. There was so somebody makes a fee waiver request. The visa will expire next month. The fee waiver decision came today, and they said that you do not meet the requirement for a fee waiver. The person has a choice of putting in the fee waiver, putting the main application. But largely, the person cannot afford, and it is true. But whatever happened, the caseworker couldn't make the right assessment. The person can put in another fee waiver because the visa is not yet expired. It will expire next month. So the person can still put in a fee waiver and make sure that they meet the rules this time for it to be granted. So the process continues. In this case, there's no Section 3C here because the visa has not yet expired. If the visa has expired and there's Section 3C protection ongoing, you cannot risk with a second fee waiver. That is the difference. So, ladies and gentlemen, viewers and listeners, we have looked at why a fee waiver application may be rejected and whether you have to make a new fee waiver application. What do you do before you consider to make a new fee waiver application? It is often possible if you want to make a new fee waiver application where you have no visa at all. You've been an overstayer, you are applying under private life. Then it doesn't matter how many times you make the fee waiver application, you are already an overstayer, so that is okay. But where you have a visa and you want to protect it, but it has expired and you are hanging on to the fee waiver that is pending, be careful. Once it is decided, you cannot make another fee waiver application because the visa has already expired. You don't want to risk becoming an overstayer with the second fee waiver application. Unless it is possible, please don't risk it. We are going to take a commercial break, but before we do, please remember the studio line is activated right after this commercial break. The lines are 020 493-7345. 0208-493-7345. That is the studio number. That is the landline. The mobile studio number is 073-9920-8468. That is also for you. It's on the screen. If you want to dial the WhatsApp number, is 07950-422-780. So these are the studio numbers. The lines are now active. You can dial in. You can also text your question to the WhatsApp chat room box, and we'll be able to pick it up and answer them for you. We go for a quick commercial break. When we return, we take your questions, we take your calls, and we will continue with the rest of the conversation. Community and the Law, brought to you by BWT. You are welcome back to the show, Community and the Law, brought to you by BWTV, proudly sponsored by BWF Solicitors. Why has my fee waiver request been rejected? And can I make another request for a fee waiver? We've delved into the conversation, we've dissected why fee waiver may be refused or accepted, and whether you can or not make a new request for a fee waiver without becoming an overstayer. We have considered all that. It is now time to take your questions. Please, you can phone in to the studio line, and the line is 073 9920 6468. 073 9920 8468. WhatsApp number 079 50 422 780. Whilst we are waiting for your calls, we'll also be looking at the questions that have come through so that we can pick and answer them. So this first question is, what is a fee waiver? So this is okay, so Monday is asking, what is a fee waiver? Fee waiver is opportunity to make a human rights application without paying the home office fee and the IHS fee if you genuinely cannot afford. You must show bank statement evidence. You must show proof that indeed you cannot afford, or even if you can afford, you cannot be able to survive on your essential living needs and that of your children, if there are, without a fee waiver. And so you are asking the government to help you pay for the application fee because you cannot afford. Show that you cannot afford. Show that after affording, you become a destitute or you cannot meet your living needs. So your income and expenditure, supported by evidence, will make a case for you or against that request. It's for human rights applications, and it's also supported by Section 6 of the Human Rights Act 1998, and also a range of case law, such as the case of Carter, the case of Gineku, and others that support the claim that somebody cannot afford a fee for human rights application. Right, so we take the next question. Can I make a fee waiver for registration and nationalization, please? You can get a fee waiver for a child's registration, but not adult naturalization application. Yes, so registration and nationality. Registration and nationality for children, yes. Adult, no. Next question. Next question from, right, whilst we are waiting for the next question to come through, remember the studio lines are now activated. Feel free to dial in and ask your question, and we'll be glad to answer them. A question from Priscilla. Hi, I'm a dependent. Can I bring my children without involving my sponsor? Um, Dependent. I suppose you are dependent, student dependent, or skilled worker dependent. You want to bring your children to the UK. Now, the sponsor obviously is your husband or your, yeah. So this is Priscilla. So the sponsor may be your husband, who is the main applicant. You need documentary evidence from the sponsor to confirm that you live with them. They are the main person on the skilled worker visa, and you live with them. And of course, they are making the application with you. He is bringing the stepchildren. Remember, you are a dependent. You are now the one making the application. He is making the application for his stepchildren. So he has to be part of this. If you need help with this, please, you want to discuss in detail, feel free to call us, book appointment, come and see us. We'll be able to work with you into detail to get it sorted. There are certain things we cannot discuss on the show. We don't have enough time, and your matter could be very sensitive. So please feel free to reach out, and we'll be able to work with you. There's also sole responsibility consideration. So Priscilla, it's important to see a lawyer. Ya Konedu is asking, can the new rules about the family and parent visa affect an overstayer who has a British baby? Right, I mean, the overstayer who has it's not a new rule. It's something that has been there. But of course, Home Office is now being strict on determining whether this British baby is indeed a British baby under Section 50 subsection 9 of the British Nationality Act of 1981, and also section 50 subsection 9 capital A of the British Nationality Act of 1981. So all these, and also the nationality paternity rules or regulation 2006, all these are things the Home Office is now looking at carefully to determine whether this person who is claimed to be a British baby is indeed a British baby. So they are working back to see whether the person was given the British passport by error or was genuinely granted. Once they pick anything up, you can challenge it, as we have already said. But of course, you can apply if you want to make an application based on your child. Next question comes from the WhatsApp feed. Can I make a registration naturalization with fee waiver? We said you can for registration, not naturalization. Naturalization is for adults. Registration is for children. So if you can't afford your child's nationality application, you can get a fee waiver. But if you cannot afford your own naturalization application, there's no fee waiver. You have to save and make an application. The next question, no, go back, producer. Bring the question back. There was the question from, yeah. My daughter and I have settled status under the EU settlement scheme, so I would like to know if we qualify for fee waiver. Your daughter qualifies for a fee waiver for her registration. You do not qualify for a fee waiver for your naturalization. So the next question. Right. In the meantime, the studio line is activated 073-9920-8468, or the WhatsApp number.
Hello.
Hello. Hi. Hello. Yes, you are through. Can you hear me?
Hello.
Hi. Yes, we can hear you. Can you hear us?
Yes, please. I'm married with someone, but I have a son in Ghana, and I want to bring him here. But his own dad is also here. Can I involve his own dad documents to bring him, or I should just involve in with my husband? I'm staying with.
Okay, what visa do you have? What visa do you have?
It's EU, and I'm about to go for my indefinite.
So you have EU 5 years.
Yes, please.
Are you an EU national or somebody from Ghana or any other country?
Somebody from EU.
What passport do you have?
Ghana passport.
Exactly. So you are a foreigner,
Yeah.
but you are a national of an EU, a family member of an EU national.
Yeah.
Right. Are you the daughter or the granddaughter or
Yes, I'm the son. I'm the mother of the son.
no, what I'm saying that okay, did you get your visa through your 5 years? Did you get it through your parents?
Through my husband, yeah.
Oh, through your so your spouse. Okay. Okay.
Yeah.
Now, are you saying you are no longer with your spouse?
I'm with him. But
Is
I'm
he
no longer
willing?
with my ex, my son's
That's
dad.
fine. Don't worry about your ex. So somebody's looking after your son for you, right?
Yes.
Is your current husband willing to sponsor the application of the stepchild?
No, please.
He's not willing. Okay. If
No.
he's not willing, then what we say is that wait until you have had your indefinite leave to remain.
Okay.
Once you have your indefinite leave to remain, you can apply for your child under paragraph 297 of the immigration rules. But you have to show that the child cannot be looked after in Ghana in Ghana. So there's sole responsibility consideration. So whilst you are preparing, when do you have your indefinite? Do you know?
I think I had my 5 years in October, but my visa will end in March next year, so I don't know when to start the application.
Okay, you can start the application in the last 28 days to the 5 years of the. Okay, when did you marry?
2020 January.
January 2020. Did you marry whilst you were in the UK or you married in Ghana and you came to join your husband?
In Ghana.
Yeah, so you first landed in 2020, right?
Yeah.
So your 5 years will start from 2020. So you can put in your settled status within the last 28 days of the visa expiring, okay?
All right.
And once you are successful with your settled status, you can apply to bring your children from abroad to join you in the UK. But you have to meet sole responsibility since the children have a father somewhere. Okay?
Okay. Thank you so
You
much.
can get in touch. You can get in touch to discuss so that you prepare yourself since you only have December to February to do anything you have to do. Okay?
All right.
Excellent.
I'll
Thank you.
contact you later. Okay.
Thank you.
Welcome. Bye. Thank
Bye.
you so much.
Okay, so that was from the caller. Any other? Yeah, so if you want to call, please remember the studio line is opened and also the WhatsApp line is open. You can dial 073-9920-8468 or WhatsApp line 07950-422-780. So these are the lines that you can dial. The phone lines are activated. Yes, we take a question that has come through to the dashboard. What's the question, producer? Can I make? Okay, yeah, this has been answered. This is from okay. If I'm on 2.5 year stay, can I invite my child from Ghana who is 7 years? And what is the requirement? So if you are 2.5 stay, I don't know the basis of your 2.5. 2.5 as a parent or 2.5 as a partner. We have to know. However, if you want to bring your children, it's possible. You have to show that if this child does not belong to the man whom you are married to, that is, if you are married and you are with your husband who sponsored you, you have to show sole responsibility for the other child. Under paragraph 297 I of Appendix FM to the immigration rules, there are different criteria A, B, C, D, up to F. A shows that you have a visa, you want to bring your child. B, C. E says that there should be sole responsibility if the other parent is not in the UK. Then D says that the other parent should have, if the other parent is dead, then you will have sole responsibility. If not, evidence that you have sole responsibility. Otherwise, evidence that if the child is not relocated to the UK, the child will not be able to survive in Ghana because the circumstance of the child is such that it's so serious and exclusion from the UK will be undesirable. So there's case law and also the immigration rule assessment to meet to bring your 7-year-old child. But it's doable. It's possible once you have gone through the assessment and met the requirements. Get in touch. We'll work with you. That is, if you want us to assist you or you want any lawyer at all. But in this situation, you need a lawyer to support you. Okay, yes. So the lines are still activated. Dial 073-9920-8468 or WhatsApp line 07950-422-780. Both are activated. Or you can send your message to the Facebook chat or the WhatsApp number. We'll be able to pick the question and answer you directly. So the conversation has been...
Hello, sir. Good
Hello.
afternoon.
Hello, good afternoon.
I've been having this kind of issue, I would say. I applied. I have my first child, who is British. In 2015, I had him, and then through him, I had my first leave. And then, but although I've been in the UK since 2004, right? So from there, I started having legal stay. So in 2018, when I wanted to renew it, I went through my lawyer, and the lawyer made a mistake. It's this year that I realized that there was a mistake he made, which is not informed me. So because this year, normally I was supposed to qualify already for indefinite leave. So now when I was about to place it in, I went through the free lawyers, and that's how they discovered that no, I was rejected in 2018. And I said, but why? They said that the lawyer submitted my application late, something like that. But I was surprised because I know that he had the money. I don't know. I paid everything, all the fees, and although I did that, he submitted my application late. So I don't know if maybe I can something can be done. I can, because they are telling me that it's like I have to lose that 2.5 years. So I need to wait for the next one. That I cannot apply this year, which I'm supposed normally to qualify. So I don't know if something can be done at all.
Okay. So what's your name, please?
It's Jerry.
Carrie.
Yes, please.
Oh, hi. Yeah. So, Sister Carrie, your question is this. There was a break during your 10 years because there was a mistake somewhere. Can this affect your indefinite leave to remain application, isn't it?
Yes, that's right, sir.
Yeah. We are not laying blame on anyone. We are just sticking to the issue, okay? That's why I don't want us to go to how it happened. There's issue, and the issue is that there was a break. So there has been a break in your 10 years continuous residence. And there's a case law called Afzal and another case law called Iyeki. The cases are both foreign nationals who had breaks during their appeal application to court and also their visa application for fee waiver and the main application because of similar errors. And as a result of that, Home Office rejected the application for indefinite, that they were not up to 10 years. They took the matter to court. And both cases, the court ruled that the break in continuity affects the 10-year threshold. And so they are not yet due for indefinite. They have to make up for the delay. Okay?
Okay.
So you have to make up for the delay. Your job now is to calculate how many months delay there was so that you can work towards that. You can now start organizing yourself, get full advice from a lawyer so that the lawyer will start working with you so that you can calculate when you are due for your indefinite leave to remain application. Okay?
So you mean that I don't have to wait for the to another 2 years and a half?
So we have to calculate. You may not have to wait because it depends on, even though you've been given 2.5 years, it depends on how many delay. If your delay is only 6 months, then you have to make up for the 6 months.
6 to 4 months, something like that.
Yeah, so you have to make up for that. I don't know, but we have to calculate.
Can I come through you? Can I
Of course you can.
can you guys help me? If maybe can I be a client or something?
Yes, of course you can. You come for advice in the first instance, then we'll understand your story. And once you instruct us, when the time is due, we'll work with you to make sure that you may also have a testimony to share. Okay?
Amen. Amen. Because I'm supposed to have done it in this October. It's this October I'm supposed to do. Last month I was supposed to have already qualified for it. All right. Okay, so I will just I will just got in contact with you guys then.
Sure. All right. Now, if you do it, if you put in the application without making up for the delay, they will tell you that you don't qualify and they will give you another 2.5. Okay. So make sure you don't waste money.
Because what I did is, I applied for the fee waiver, which was granted.
It's
I
the
made
same
an
thing.
application for the 2.5, which
It's
is
the
still
same
working
thing.
right now. So
It's
I
the
wanted
same
to
thing.
place in now for the indefinite.
That's why I'm saying that
But
you didn't qualify. You didn't qualify. That's why they gave you 2.5 again.
Mhm.
Okay. Thank you for
Thank you.
phoning, and please feel free to get the number. The number to dial if you need to speak to us. With the office number is 020. The office number is 020-8493-7340. 020-8493-7340. Or you can phone the emergency number, which is 077-1276-1884. 077-1276-1884 for emergency cases. If you are in Ghana and you want to speak to us through our office in Ghana, the number to dial is 055595958. So these are all the numbers on the board. 5959. So 055-589-5959. That is the Ghana number. All right, so we move on to the conversation. If there is any question that has come through, please, producer, get the number on the screen. We have to be wrapping up very soon. Okay, so this is the question we take, after which we'll go into the nugget and give you the question and take your answers. Also, can I make a registration actualization application at different time apart? Of course you can. Of course you can. Okay, you can do for your child and later do yours if money is an issue. So you can do at the same time, or you can, if you can start fee waiver for your child whilst you use the money available to pay for yours. And whilst you are waiting for the fee waiver for your child registration, you'll be getting through with yours. Because yours you have to pay. The fee for yours, which is naturalization, is £1,735. So you can do that whilst you are waiting for your child's fee waiver request for the registration for the child. Okay, so we are going to the questions. So the question time to test your knowledge and to see how you've understood the legal point within the nugget. So the point within the nugget is right of tenant who have paid deposit to a landlord or to agent. The deposit, you can't tell whether it is, and they are not giving you any information. Should you wait or not? The law says you can request And if they don't give you the information within 30 days, you can go to court and get the money back plus more. So Ashraf entered into a 1-year tenancy agreement on 1st January 2025 with Umar Patel. He paid 1,500 to the landlord's agent. He has been chasing the estate agent to confirm the name of the deposit scheme the money was paid into. Up to date, in November, nothing has happened. No information, no update, and he doesn't know whether the money is in somebody's bank account or the money is actually with a deposit scheme. Advise him. He has to complain, or he can complain to the legal ombudsman to get his money back, and he will receive 4,500 back, or he should apply to the county court for an order to get his money back, and he will receive 4,500. Or he can do number 1 or number 2, any of them. What do you think? Please, we are waiting to hear from you. Mami Yakun says number 1. Thank you, Mami. Mami is saying that Israel can go to legal ombudsman. Naomi is saying number 1, Israel can go to legal ombudsman. Someone is saying both number 1, number 2, it doesn't matter. Kweku is saying number 2, he should go to court. Efia is saying he should phone the legal ombudsman. Lydia Opon is saying he should go to court instead. Nanaya is saying, I agree, he should go to court, not legal ombudsman. Daniel is saying it doesn't matter, legal ombudsman or court, they are all powerful. Juliana is saying number 3, both of them. Michael is saying number 2, only court. Blessing is saying number 1, only legal ombudsman. Nana is saying number 2, go to court. Akosia is saying number 2, go to court. Hannah is saying number 3, go to court or legal ombudsman, doesn't matter. Hagar, go to court or legal ombudsman, doesn't matter. Albert, go to the legal ombudsman. Right. So thank you very much. It's been a very competitive contest. All the candidates are doing so well. So far, so good. Now let's go to the nugget so that we situate the response within the law. So this is the nugget. Under a short hold tenancy agreement, a landlord has a duty to protect a tenant's rent deposit through a deposit protection scheme. This duty must be carried out within 30 days of receiving the money. Failure to do so may lead to the landlord paying back 3 times the deposit amount to the tenant within 14 days of a court order. Section 213, Section 214 of the Housing Act 2004. So it says of a court order, That means the best option would be, Tilly has just handed in her script, and she's saying that number 1, legal ombudsman. Thank you, Tilly, for bringing your script in. Okay, so the rules say that to be able to get the money back, it must be by a court order. And so the only place to go to should be court, because legal ombudsman will not give an order. So the answer is 2. Go to court. If you don't have information within 30 days, the court will make a determination and issue an order. Within 14 days of the order, landlord must pay back the original deposit money of 1,500 plus 2 more, making 1,500 plus 3 times 3. That is 4,500 pounds. So, wow, that's good news for tenants, isn't it? Pray that the landlords make mistakes, they can take advantage of the law. Landlord, make sure you don't make a mistake. Otherwise, you cough up more than you received, and you still allow the person to stay. So this is the nugget, this is the question, and this is the solution. Thank you for your time. Thank you for staying glued, and thank you for your patience. Now we ask Lawyer Charles to summarize today's conversation point for us. Okay, so today we looked at fee waiver application. Why is it rejected or granted, and whether I can apply again? We understood that fee waiver is a human rights support for people who cannot afford application fee for human rights applications as a parent, as a partner, as a under private life, under discretionary route, and so on and so forth. As far as it is within Human Rights Act Article 8 or General Human Rights, and also the Human Rights Act 1998, European Convention on Human Rights. Now, under Section 6 of the Human Rights Act 1998, if the Home Office forces somebody or asks somebody to make a fee payment before their visa can be made, and the person is not able to do so, it is in contravention of their human rights. And so, fee waiver is to ensure that the government protect itself. But your job is to make sure that you qualify for a fee waiver. So you must prove that you cannot afford, or even if you can afford, you cannot live after paying the fee, and or your children involved, you cannot feed them or look after them, because if you use the money for their feeding and support to pay for the fee. If these are the considerations, then the caseworker must consider to give you the fee waiver. Your job is to show that your income and expenditure, weighing the two up, show that your income is not adequate to be able to afford the fee. The caseworker will consider and grant. If they decide not to grant, it means that you have done something that means they cannot grant you the fee waiver. One, you've deliberately spent the money so that you can avoid the fee. If they find out, they will refuse. Or two, you are spending unnecessarily on other things, and so that is why you don't have money to afford the fee. Or your evidence supporting your claim is not enough. Or you have not been able to explain all your income and expenditure fully, and so they think there's something that does not add up. All this will be the reasons, but they have to tell you. That is the reason why you may be accepted or rejected. Can I apply again? We said that you can apply again if your visa has not already expired. If your visa has already expired, don't attempt another fee waiver. Put in the main application within 10 working days given to you. Otherwise, you become an overstayer, and your protection under Section 3C of the Immigration Act 1971 can no longer be valid. This is the conversation for today. Thank you so much for joining. It's been a wonderful moment. We've brought you 2 hours solid conversation, and we believe that you have benefited immensely from today's show. Join us again next week. Join us on Thursday when we bring you Legal Hour Show, and also Friday when we bring you another episode of Legal Discussion, and again Saturday for another Community and the Law program. Remember to get in touch if you are coming to us or looking for us. We are located at High Road 214 to 218, and the address is Anna House, and the contact is 020-849-37340, and the emergency contact is 07712761884. Thank you to everybody who contributed to the show, the executive producer, the organizers, all the research team, and of course, the social media team. Thank you very much for adding to this wonderful piece. It's been your host and your guest, Charles Asma, the servant of the community. Thank you, thank you, thank you.